Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument in JV24-0181. These proceedings are being video and audio recorded and live streamed. So we ask counsel to please identify yourself and your client at the beginning of your argument. As you both know, each side has up to 20 minutes. Appellant's counsel is responsible for watching the clock if you'd like to reserve any portion for rebuttal. Also, please keep in mind that we've read the briefs and conference the case this morning. And with that, counsel, you may proceed.
May it please the Court. I'm Peter Swan, and with my co-counsel Amy Wilkins-Hoffman, we represent Mother in this appeal. I'd point out that Denise Carroll, counsel for the child, who has also taken the position that termination is appropriate, is present here in the gallery today. I'd like to begin by addressing the questions contained in this Court's recent order. I think the question really boils down to this. Does a party to a private termination forfeit her appellate rights by entering into a Rule 69 agreement in family court while the appeal is pending? In other words, does a new parenting plan moot the appeal on a case involving abandonment? I submit the answer is definitively no on both legal and prudential grounds. On the law, this Court in JS1363 held that consideration of subsequent remedial measures is inappropriate because it would denude the statute and basically eliminate private termination actions. And if this Court were to hold that a Rule 69 agreement during the pendency of an appeal moots the appeal, it would be doing exactly what JS1363 held inappropriate.
So counsel, let's stress test that a little bit. Let's say that you win your appeal on the basis that you demonstrate that the court erred by not finding abandonment by clear and convincing evidence. You still have to show on remand best interest. Now you have this argument about a motion which you contend demonstrates that father was not acting in child's best interest, but reading out of some of the matter that you submitted to our court as a stipulation dismissing the family appeal, the failure to have the minor child fully participate in the parenting time plan would be to the potential detriment of the minor child's emotional development, and here's the key, contrary to the minor child's best interest. It's not abstractly that it's moot, counsel, it's that you've stipulated that as a go-forward, father has joint legal decision-making, and it is in the best interest in your client's view. So if you win the statutory ground for termination, how on remand could you fail to lose best interest? Haven't you stipulated away the issue that you're seeking a retrial of?
Absolutely not, Your Honor. I would point out first that stipulation, and I welcome the courts taking judicial notice of any records in the many pieces of litigation that surround this situation. I'm not objecting to that at all. That stipulation was entered into by the family court counsel for purposes of the family court, and it boils down to
Mother's family court counsel.
Yes, Mother's family. No question. The stipulation is Mother's stipulation. It's binding on Mother, and I'm not going to try and run away from that at all. What I'm going to do is explain what I think is really the global import of the question posed in the order, and the global import goes not only to this case, but to all cases in which there are two tracks. And in a private termination action, there generally are two tracks. There is the family court, which lacks the power to terminate, and always, under Arizona public policy, strives to create a stipulation or an order, if the case is tried, for a parenting plan that involves both parents. And it is essential in every single one of those cases under 25403 that the best interests of the child underlie the agreement. Now, while this appeal is pending, and for the last 3 years, Mr. Vernick has had parental rights. And I could go into great detail about the course of litigation in 2025 that led to Judge Brooks spending 3 full days mediating this dispute and coming up with this interim parenting plan, which must be supported by a best interest determination, but always, in every case, not just this case, there are 2 tracks. And while the termination is pending, the child is still alive, both parents still have rights, and the family court does what the family court must do. So in the alternative to termination, if Mr. Verning is to remain this child's father, it is important that she experience that reality in the most positive way possible. Now, I would point out to the court that in this case, well, let me back up and deal with a prudential issue also, because if the rule were that by entering into a cooperative parenting plan rather than simply digging in and doing scorched earth litigation, if the rule were that one then loses a termination appeal or loses the right to appeal, the incentive would not be for parents to act in the best interest of the children. And this mother has done that.
Counsel, I don't mean to interrupt, but I do want to make sure to get an answer to the focused part of my question, which is, how do you win best interest on remand? Haven't you stipulated to best interest? You see, it sounds like you're saying you did it sort of contingently or for the benefit of the child, but like you're kind of holding yourself out of the stipulation. Mother has stipulated it is in the child's best interest to be with father going forward, and joint decision making, which is very important for that process. So wait, counsel, wait, sorry. So how, when you go back, do they not just file essentially a summary judgment motion saying you stipulated to best interest because there are 2 courts, but there's 1 child?
That is a well put, Your Honor. There is 1 child, and this 1 child is living a day-by-day reality while the court system does what the court system does. If this case is remanded for a best interest determination, there is ample grounds for mother to try this case on best interest, and I'm sure the court is aware of some of the issues surrounding best interest.
So she'll collaterally attack her own stipulation by using what's in your appellate brief.
She will actually
Counsel,
take advantage.
that's the question, is how do you get around the stipulation?
You read the express language. It is in the best language. It is in the best interest of the child under the circumstances of this case. This case being a family court case that may not exist if this court reverses, remands, and a trial court finds that best interest is not met. If this court were to affirm the finding of the juvenile commissioner that the grounds of abandonment were not met, then that's the reality this child faces. And so there's no co-parenting in this plan. There are major therapeutic milestones that Mr. Verning has to achieve before he has any meaningful involvement with the child. Yes, that is in the child's best interest, because earlier
they have joint legal decision-making authority.
With mother having
right?
with mother having final say, yes, and the Supreme Court has upheld in Nikkei's that sort of arrangement. Mother has final say. They, for the moment.
I'm not questioning the arrangement. I'm questioning your comment that they're not going to be co-parenting.
Well, if one reads the parenting plan, mother has final say over many issues. There are some. There's a burden-shifting due process procedures spelled out in the attachments that specifically gives father right to comment, gives mother final say, governs when parties can bring the dispute to court. It's very, very detailed and very, very protective of the child. So versus the position father took earlier this year, which is that the child should be removed from mother's care and placed with a third party, yes, it's in the child's best interest in the circumstances of this case. And that's what the stipulation says. So we would rely on the text of the stipulation to point out that this case referred to the family court, and in the circumstances of this case refers to in the circumstances of the family court case, which I submit to Your Honor should not exist. I submit that no court, few courts, would place their imprimatur on the fitness and the best interest determination of a parent who repeatedly denies his own paternity and claims that his own child is the product of an incestuous relationship.
Counsel, I want to back up to something you said a minute ago, because you're telling us we have to stick with the language of the stipulation. I have it in front of me. Attachment A, parenting plan and legal decision-making. You said mother has final decision-making. Page 2, legal decision-making, I'll read it to you. It is the intention of the parties, by agreeing to joint legal decision-making with neither parent having final say, that both parents will continue to have an active role in providing, et cetera. So you just told us about 2 minutes ago she has final, and page 2 of attachment A says that it's joint and she doesn't have final. I don't understand, counsel.
Well, it would require an extended read to look at the procedural breakdown of how that decision-making goes. It is broken up by subject, and if you read the process, mother clearly has primacy over many decision-making issues. But the joint legal decision-making at this point is hardly the issue.
So it's true that neither parent has final say, as it says on page 2 of attachment A, right?
It is perhaps true that no parent has final say, but it is also true that mother has primacy on many issues.
Okay, we accept the clarification.
And I appreciate
Thanks.
the clarification, Your Honor. But I submit that the family court case, in the circumstances in which this best interest agreement was reached, should not exist, because to say that this stipulation trumps best interest for all purposes would be to ignore the record exactly the way the juvenile commissioner did. To ignore what this man has done to this little girl, what he threatens to do to her, and to ignore that under Demetrius, this little girl has a very close bonded relationship with mother's husband of 2 years, lives in Florida with the blessing of the court and the consent of father. And her best interests clearly are served by maintenance of that relationship and the avoidance of the harm done to her. Now, the avoidance of the harm done to her is captured somewhat in the phases of the parenting plan. Those phases involve significant therapeutic milestones that the father in this case has to achieve before he can begin any sort of normal parenting relationship. Compare, if you will.
Doesn't that support father's position? I think what the juvenile court found is that he couldn't just show up and start having visitation with this child. There needed to be a process, and mother fought that process tooth and nail at every stage.
Mother did not fight that process tooth and nail, Your Honor. For years, this man has had court-ordered visitation, court-ordered parenting time, supervised parenting time that he never exercised. This is not a case in which mother has fought it tooth and nail. This is a case in which mother has fought tooth and nail for the child, because this man would have the child removed and placed with a random third party. She's doing well. She has no reason to be removed. And all of this discussion that we're having, I submit to you, is fodder for remand. These are factually intensive questions that require a deep understanding of the record that in my remaining 2 minutes and 43 seconds, I am not going to be able to give you. And frankly, it would be inappropriate for me to argue all the facts here. But these are factual questions. If one can say, as a matter of law, that this stipulation is binding on best interests, then let's roll back the clock to when this case was decided.
But
and I would submit to you
counsel didn't we have competing presentations of fact at the before the juvenile court, and the court made credibility to findings. So are you asking us to send it back and say, try it again?
Absolutely not. Absolutely not. First of all, the court made no best interest findings. It disclaimed making a best interest determination because it didn't find grounds. It found that mother had not met her burden of proof. I submit to you that based on the undisputed facts, if mother had no witnesses, if mother hadn't shown up.
Give me a couple of undisputed facts that need to be highlighted on abandonment.
Happily. This is all, everything I'm going to tell you is testimony that came from Mr. Verning's own mouth, the person who the court found eminently credible. He testified he has not maintained a normal parent-child relationship since August of 2021. He testified that he has not maintained regular contact since August of 2021. He testified that he has not gone out of his way even to contact the child.
For a year after August 2021, his rights were terminated, correct?
His rights were restored in
2022.
2022. And in 2023, we watched in slow motion him abandon this child. Hundreds of hours he spent in the same courtroom with mother. Never once did he even ask how the child was. He didn't know if she was sick. He didn't know if she was healthy. He didn't know what she was doing for Halloween. He never even talked to mother, much less reached out to the child. And all of the cases on abandonment say that this is per se abandonment. If we had had the record before trial that we have now, this would have been summary judgment on abandonment, not by clear and convincing evidence. This is beyond a reasonable doubt abandonment. So the question then becomes, at the time the court decided this case, this stipulation didn't exist. So if this court is going to announce a new rule...
What if it had? What if it had existed? Could the juvenile court look at it and say, not as a matter of law, this forces me to deny the petition, but I'm going to rely on it, and I'm going to say that it strongly, I guess, weighs against mother's argument that termination is in the best interest of the child?
If it had existed at the time and the court wished to consider it, and had it considered the other evidence, which our brief points out the court actually misstated in its ruling, just ignored completely and denied the fact that the incest allegations ever occurred. If the court considered all the evidence, including that stipulation, I would agree that's proper fodder on remand for a factual determination. Now, Your Honor,
But I thought you've asked us on appeal to decide that it is in the best interest of the child for termination to have occurred. I mean, you said the juvenile court didn't make best interest findings, but there are at least 2 pages of discussion about it in the minute entry. And I thought you were asking us to, similar to what we did in Ray CE, to say on appeal, no reasonable fact finder could say this isn't in the best, termination is not in the best interest of the child.
yes, I did ask for that.
Okay.
And that was
Are you
before.
still asking us to do that?
I am, because I think the facts here are that extreme and outrageous, but I recognize...
But in doing that, we can't look to this agreement that now exists?
I don't think you could, because that would involve weighing facts. And so I acknowledge that at this stage, with this stipulation, the more appropriate course is a remand to the trial court, specifying that the grounds of abandonment were met, but the trial court needs to consider all the facts, including the Rule 69 order and the subsequent performance of Mr. Vernig under that order, all of those facts, in making its best interest determination on remand.
So, counsel, are you aware that under Rule 56 that you can't create an issue of fact on summary judgment by arguing with yourself?
I'm quite aware of the contours of Rule 56, but I'm not sure that I understand...
There are a lot of cases that say you can't create an issue on summary judgment under Civil Rule 56 by disputing a fact that you yourself admit. Are you aware of that?
Yes, and I'm not trying to do
Okay,
that.
so I guess what you're saying is that the stipulation about best interest really isn't a stipulation that it's in the best interest going forward to have the parenting plan in the stipulation. That must be your argument, because you just said otherwise summary judgment can be appropriate on remand in this case.
On
in fact, you're
grounds.
asking us to enter it.
I said on grounds. And at the time I invoked CE, this stipulation did not exist. So I am recognizing that it may be a prudent course at this point, given the court's concerns, to remand. If I may, Your Honor, I'd like to reserve the remaining 2 minutes. Thank you.
Thank you.
Good morning, Your Honors. I'm Alex Polis. I represent father in this matter. Amy Sells is seated in the audience as well, who's joined me on the brief. In answer to the court's question that you asked us to address, where you're asking if the court can reverse the order given the Rule 69 agreement in order, my answer to that question is no. The Rule 69 agreement is the grand convergence of everything that matters in a termination case. The parents aligned. The child's best interest is included in this. Judicial integrity is included in this. A quick resolution of the matter, which is what this court is required to do on any sort of appeal. Rule 69 agreements by rule and law are binding on the parties and on the court once the court accepts it, and the court ordered this as a final order under Rule 78C.
Do we risk disincentivizing, though, parties from entering into these types of agreements if we do what you want to do here?
Well, if the child's best interests are at stake, and that's the underlying factor motivating both parents, then the parents individually are going to have to exercise their rights in making that decision for the child. We can't assume that just because both parents go into family court and reach an agreement that somehow one of the parents was treated improperly because, well, I've got an appeal over here in the other court. Nobody forced her to enter into this agreement. As the court knows, Rule 69 requires the parents to enter it knowingly, intelligently, voluntarily, without threats or coercion. So she has admitted she was not coerced in any way, whether it's some sort of legal impediment to what she wanted to do or whether someone was forcing her to do it physically. She made this deal. So I would ask the court.
What is the framework upon which you're asking us to consider the agreement? Is it estoppel of some sort?
Yes, kind of. It can be.
What type of estoppel? There are lots of different types.
Right. Under Benino and Lawrence, T, I think is the T, the court considered res judicata and claims preclusion. The other one I would argue is judicial estoppel. Both those are usually involve the same sort of factors, same parties, same issues, and you get a final judgment. In this case, we do have that in the family case where mother entered into this agreement. And I would argue, even though in Benino and Lawrence K, the court, forgive me, I'm saying K, it might be T, but in Lawrence, even though the court avoided applying claims preclusion, it actually gave an interesting comment in Lawrence, if I may. Give me one moment here. It does say in Benino and Lawrence that the court should do it sparingly because the child's best interest is not a static circumstance. But what's interesting in Lawrence is it actually distinguished when you would apply that. I've got it right here. So in Lawrence, I believe it's paragraph 14, it says, thus the relevant question is not limited to whether a material change in the child's circumstances has occurred between termination proceedings, but whether generally there is evidence of changed circumstances that could affect the juvenile court's determination regarding the statutory grounds alleged and or the child's best interest. In this case, on Rule 6, now, by the way, Lawrence was looking at a circumstance where you had a mother and father who DES went after. They succeeded in getting mother's rights terminated, but there were two children left behind that father still had access to. Then DES went after that as well with a termination petition. Father argued claims preclusion, and the court came back and said, well, there's been changed circumstances since then. The law, Ken K., Bobby, and so on, does talk about when the court considers best interest, it considers the best interest at the time of that new adjudication. It isn't stalled and stopped from the past one that's being appealed on. So in those circumstances, the court was saying, there's new evidence that arose. We can't just tell you claims preclusion and end the case. The state has an opportunity to address this issue in the child's best interest. In this case, you have a month ago, mother entering into this agreement saying it's in the child's best interest. And not only that, but the order says that the court finds that both parents are fit to parent the child. So you have the two-step inquiry where you have to find grounds. Those are proxies for parental unfitness. And then you also have what I'm going to call CBI to make it easier to, at a preponderance of the evidence level too, by the way. That's the burden that's applied in family court, preponderance of the evidence. The difference here too you have on claims preclusion, by the way, versus issue preclusion. Claims preclusion does not require an adjudication of disputed facts. Very important distinction I'd ask the court to consider. So if you are going to apply claims preclusion, you do have the opportunity to say, just a month ago, you just agreed that father was fit. You agreed with what the court found. and you agreed that it was in the child's best interest to stay connected with him, and even, the legal decision-making argument, to follow up on that, it's presumptive decision-making authority, which is, the family court's been using that. It's not final say, it's not sole, but, mom can make the call. And in this case, because it was a relocation, she's in Florida, dad's in Arizona, mom can make the call because she's right there with the child. And then dad can come in and
Sorry to
question.
interrupt.
Sure.
What would we do with the agreement if we had a situation where the juvenile court had terminated? I know it's a lot less likely that this sort of agreement would be created there. I think what's unique about this case is the trial court denied termination. And so I think it's a little maybe easier for us to say, because we're now basically being asked to overturn that we can look at new developments that have occurred. But if there was termination, I think it would be a lot more clear that we'd be locked into the record as it existed at the time of termination.
Well, isn't the answer to that before the rights are terminated based on the grounds, the child and the father's interests align all the way, even when they were over there in family court making the agreement. Judge, I'm not sure if a termination occurred would be a decision this court would have to make, because I don't see, forgive me if you can help me, I don't see how it's relevant, how it would be relevant to the court's decision to make under these present circumstances, where his rights were not terminated as the question was posed. The court was asking, can we go back and reverse based on the past, when now, while his rights were not terminated, you entered into this deal? And it was an agreement, that's the key, even though it's court order, it was an agreement. And you've basically admitted to the issues you're contesting in juvenile court.
Counsel, if I could just jump in, because I actually had a case 2 years ago I worked on, and I wrote separately a 2-paragraph concurrence about whether you could stop somebody out of being a parent, and I stated, anyway, there's 2 parts to estoppel. There's whether all the elements in this proceeding are in line with this proceeding or this order with this situation. But the second one is it has to be in the interest of justice to apply estoppel. It's a discretionary thing. Even if estoppel was classically met by elements of claim preclusion, we don't have to do it, right? Right, okay. So I guess it may not represent a difference, but please walk me through what a non-estoppel outcome would be, to use a different fork on the flow chart here to analyze this. Because isn't it correct that they've admitted best interest? So it's more like a CE situation, isn't it, where we would be deciding that you couldn't decide it another way, as opposed to deciding you can't deny it. It's like you admitted it. Those aren't the same things, are they?
Right. I went to the estoppel issue because the question was asked,
Sure.
but I would argue to the court, consistent with what you're talking about, this court in the past has, on In Re CE in 2025 and Oscar O in 2004, made the direct decision at that point that the court reversed orders denying termination and directed entry of a termination order, because there was no evidence that of the child's best interest being in favor of maintaining the relationship. So the court looked at the evidence issue, did not weigh the evidence, it looked at the record and said there is no evidence. And so it didn't apply estoppel at all, it just sent it back and it directed the order. In addition, on Jade K in 2016, 240 errors 414, and Titus S 2018, 244 errors 365, this court reversed the temporary orders for lack of evidence without remand. So in other words, estoppel was never applied, and I would argue this court does have the authority to simply deny. In this case, what you're doing is just denying mother's appeal. You're not giving any directives back to the trial court. You're just saying that, look, in this case, if we're going to look at the fact that there's no evidence to support what you're claiming you want to go back to the trial court and claim, because you're going to have to consider, the trial court's going to have to consider best interest. Because we as a court have to decide things quickly, and we shouldn't keep the child in limbo, we're not going to send it back and have another 8-month trial or even something less. We're going to finish it now because, Mom, you agreed. You agreed to do this. And the court ordered it. And the one superior court, as defined in Angelic R.V. Popko, the first ruling that ever came out on this case, made it clear it's one superior court, the divisions are imaginary, and it also emphasized the importance of maintaining judicial integrity. No one should be able to, if you remember those old comedy routines with Red Skelton, knocking on the door of the bureaucrat's door, answer the door, you get your service, and they tell you, go to the next door, you go to the next door, and it's the same guy at the door.
Yeah, I suspect there are superior courts in Arizona where these two cases would be in front of one judge.
The same judge. Eunice, for example, because I've been out there recently. And so they keep changing hats and then say, oh, okay, now, what are the facts here, folks? What's that doing to the child? What's that doing to the integrity of a father, for example, who, if he did not have the means, he would have been steamrolled in this case, where he spent all this time trying to get back with his child, and Judge, as you pointed out, the mounds of evidence showing that mother kept blocking his access under Calvin B. Mounds of evidence. Restricting his ability to engage in a normal relationship with his child and to maintain regular contact, as the court described based on the law, which says those terms are elastic. The court went into detail in a 143-page ruling that said this guy tried everything.
What impact does In re BW have on this case, which is the recent
Good question.
Supreme Court opinion?
In re BW, I think helps father's position because it gave some definition to those terms, but I would argue that it did not overturn or reverse or change the notion that the application of the terms of abandonment as well as just cause, or they remain elastic.
I think one could argue the Supreme Court went further than we did in Calvin B. in defining just cause.
Well, and it's interesting because the issue of as you know, BW sent it back on advice of counsel.
Right.
Telling the trial court, go ahead and consider if this is a means, a reason. The issue came up in our trial, and I know the mother's counsel argued, well, there's no basis to argue advice of counsel as just cause. Well, BW has made that point clear. So what it's emphasizing, which is what the Supreme Court has also been emphasizing in Briona, Alma S., where it sends cases back to the Court of Appeals or the trial court, is look, termination, I'm using my own words, is the death penalty to parenting, period. And there better be darn good reasons why you're going to sever the person's inalienable rights, which were father's, because he had established a relationship with his child. So rather than a trial court committing an error of law and saying, well, just cause just doesn't, advice of counsel doesn't count, the Supreme said, no, you better take a closer look at this, because if he had a good faith belief that based on his legal advice he shouldn't be doing a certain thing, you've got to address that to see if that was a basis to terminate his rights. So I'm sorry, I don't know what time I have. Is it 5 minutes?
I guess what is the good faith belief here?
Well, the good faith belief
It's
here...
not limited to advice of counsel.
No. The good faith belief here is, number one, he only found out about it in August of 21. His rights were terminated for 1 year. Even then, he still tried to get access. He sent a request in November 2021. It's in the ruling. Rejected immediately. He sent a request in December for parenting time as part of an agreement. Rejected immediately. He did it again in March of 2022. Rejected immediately. When he finally got his rights back in September 22, he filed with the family court to get to modify the current orders, and immediately mother appealed. She filed a second termination petition to freeze him in juvenile court, and then she filed a motion to stay the family court proceedings. For the entire fall, father was sending letters, trying to get parenting time, which was court ordered because there was no more termination order. And mother took the position, it's in the order, I am not giving it to you until the family court rules on my motion to stay, and if they deny it, until the Court of Appeals rules on the special action. So she refused to give him access. Then finally we roll around in January of 2023 when she finally gives him access, and all of a sudden, as the ruling notes, in January January of 23, the child is extremely afraid of father when the last time he saw him on August 2021, and there's a photo in the ruling where she's smiling at him and they're playing water balloons. So that's his just cause in that period. Then when he got in, the child screaming and crying, we tried it again Feb 4. What happens then is we had a supervisor at the time. Father made headway in 2 hours, and mother unilaterally fired her. So then the next time we tried May 1, the child wouldn't even get out of the car.
And then father, going forward, sought visitation with a third party there to help the child, right?
Because he filed in February when we realized what was going on Feb 4, mother intervened and fired the person who was going to facilitate. He filed and asked for court providers, right. A TI, an LFA, a parenting supervisor to try to facilitate it. And mother stalled that with her stay, which ended up in the Ryzik v. Jackson ruling in August of 2023. Whereas the court knows, mother
and we now have an agreement from mother that a third party is necessary, at least at this point in time.
At this point, because of what occurred with the child unrelated to father's behavior, and fortunately 25-410 and Rule 81 allow for that so he can develop a relationship. And by the way, counsel referred to as an interim parenting plan. It's not interim, it's a final order. It's the parenting plan he's left with basically after the destruction that occurred throughout the juvenile proceedings.
Does he have joint legal decision-making?
He has joint legal decision-making under as the order reads, with the subset that mother can make a presumptive decision and then father can come back and either try to work it out with her, and if not, then he can take whatever actions are necessary if he disagrees with her. So again, I stress, the presumptive decision-making authority is only like, I'm going to make one right. First of all, she doesn't get just to go out and do it. You got to consult. Mm-hmm. But if it's like, I got to take her to the doctor, she sniffles over that, she can do that. If father sometimes disagrees with, for example, the doctor's recommendation, mother says, well, I want to go with it. Well, then father, unless it's an emergency, can seek a second opinion and pursue the prospect of making a joint decision with her.
So does the agreement establish a co-parenting situation?
Absolutely. Absolutely. He gets decision-making. By the way, there is a family case, and I can't remember which one it is, but it refers to 1602 and 1601, as the court knows, is codification of parents' fundamental rights, and that case refers to the fact that those statutes refer to legal decision-making. Are there any other questions?
Thank you, counsel.
Thank you very much.
The argument you just heard illustrates exactly why this is a factually intensive matter that can't be appropriately addressed at the appellate level on best interests.
I guess that assumes that we have disagreed with the juvenile court's abandonment analysis.
Well, yes, it assumes that you see the merit of relying on the father's own testimony rather than the argument Sure. Mr. Poulos makes. Are
there any other prior circumstances where this court or the Arizona Supreme Court has basically found the statutory ground for termination on appeal?
We
have CE where we sort of did that on best interests. I'm interested, do we have anything similar with respect to statutory ground?
To my recollection, all of the cases in which the statutory ground was not found and this court reversed involved a remand. In this case, this is unlike any other case I've ever seen at so many levels, but in this case, you have father testifying. He didn't go out of his way to see the child. Mr. Poulos will tell you something different, but when father got his rights back, remember, it took him 8 weeks to ask for parenting time, and he made sure he sued everyone first. If you want to know what this case is about, I would ask the court to take a look at the exhibits to IR 776, and that will tell you what's really going on in this case. You didn't hear in the appellee's argument any refutation of the conduct that gave rise to our original argument on best interests. You didn't hear that a refutation that he denied his own paternity, and in fact, the family judge said in a minute entry on 8/20 of this year, father made the allegation, not mother. He's responsible for it. There's no meaningful dispute. It was made, and I suggest that if this court is to place its imprimatur on such conduct, it should publish. It really should publish, because that would be a brand new doctrine. The parenting plan in the stipulation points out, and I see my time is up, but if I can finish my sentence.
Sure.
Just points out that it is subject to modification and sanctions if the parties don't comply, and the one with the milestone here is father. So is it a 78C signed judgment? Sure. Is it subject to modification at any time, including the underlying agreements? Sure. This stipulation postdates the date on which the trial court committed error, and I urge the court to remand. Thank you.
Thank you, counsel. Counsel, thank you to both sides for your written briefs and your argument here today, giving us much to consider. We'll take the matter under advisement and issue a written ruling in due course, and we are adjourned.